As you begin working on how to draft different types of correspondence, like client letters, demand letters, and settlement offers, you will also need to understand how and when to best use email. We all use email regularly, but using email in a legal context raises some very important issues that can have an impact on how you practice law. This unit will cover how to use email appropriately in law practice. We will cover 3 basic topics. First, when should you and should you not use email? 2, how to properly draft an email in a legal context. And 3, how to avoid common problems in using emails. Let's begin by discussing when you should use email. The overall guiding principle for deciding whether to send something in an email is whether you don't have a problem with others seeing it, including any opposing counsel in a lawsuit. You can always assume that emails will be forwarded and that they may be discoverable in a lawsuit, which means that another party to a lawsuit can get copies of them. You may take many different steps to avoid your emails from being forwarded or discoverable in a lawsuit, but you shouldn't assume that they won't be. Remember, if you can simply call your client or opposing counsel, that is often a better form of communication about sensitive and potentially harmful issues. Plus, there's no written record that can be discovered or forwarded. So remember, once you send an email, it becomes a permanent record and may never go away. A phone call only leaves a record of when and to whom you called. Now that you determine that you want to send an email, you need to make sure that it contains all of the important information to make it effective. In our personal lives, we often use email and text messages to quickly talk with other people. We will often be very informal in the way we convey our thoughts by using abbreviations and emoticons, while not adhering to general grammar and punctuation. You simply cannot do that in emails for law practice. Here are some tips on what you should include in your emails. First, you must use a professional email address. Have a domain and an email name that is tied to your practice. If your law firm is Smith & Jones LLP, for example, you may want to purchase the domain smithjonesllp.com for your emails. Don't use free email domains with silly or unprofessional names like bestlawyer@yahoo.com or thepackerssuck@gmail.com. Second, the tone of your email should be professional. It should always be written in a way that makes your thoughts clear. Don't try to be funny and don't try to be sarcastic. People will not always know that you are being funny or sarcastic. Instead, they may be offended or confused. Simply make your point in a clear and concise way. If the email can be misconstrued in any way, just don't send it. Call the person instead. Which leads me to the next point. Make your emails short and sweet. Do not be wordy. If you need to make any clarifications or give more details, simply ask the recipient of the email to call you to discuss the matter further. In fact, an email that asks the recipient to call you may be the best way to communicate on sensitive matters. Write the body of the email similar to what you would put in a letter. If too long, summarize and attach a letter. Assume that the reader will only view the screen and not scroll down. Grab the reader's attention immediately. Use plain text. Do not use any fancy formatting or strange fonts. Times Roman or Arial are the best fonts to use. Be sure to use a descriptive subject line so the reader will open it. Avoid subject lines that say hello or legal matter. Use something that will show the urgency of the matter or the specifics of the matter in the email. We all receive so many emails a day that you want to be sure that the person actually reads it. You may also want to use the return receipt function, which allows you to know when a recipient has read your email. Use CC only when you want those people to view and not respond to the email. If you want somebody to respond to the email, put their address in the to line and start with the body of the email with the names of the people the email is directed to. Include a signature line of all your professional information, including phone, cell phone, fax, email, web page, and email address. Make it easy for the reader to find you. Finally, include a legal disclaimer that attempts to protect you from inadvertent disclosure. If an email is sent to someone who is not supposed to see the email, the disclaimer could be used to protect you for waiving any attorney-client privilege. Essentially, any communication between you and a client in anticipation of litigation or for a legal matter is protected by attorney-client privilege. That means opposing counsel can't see the communication unless you waive the privilege. You can waive the privilege by allowing the communication to go to other people. A disclaimer can help you prove that the disclosure to a third party was inadvertent, and courts are sometimes willing to say that the client and attorney did not intend to waive that privilege. Here's a typical waiver. Simply, the notice should say that the matter is confidential and to alert you immediately if the email went to an unintended party or person.